Good morning, everyone. Welcome to today's webinar, which is titled Just Because. My name is Christopher Justice, and I'm joined here by my colleague, Mackenzie Irwin. And we are here today to talk to you guys all things just cause related. What it is, what it means, how the courts have treated it, and what consequences flow as a result of a decision to terminate for just cause. And so with that said, I will begin by giving a bit of an overview of just cause generally. So just cause, in the eyes of the courts, has been deemed to be the capital punishment of employment law. And that's because if it can be made out by an employer, and that's a big if, it would essentially result in that employee leaving the company and receiving little or no severance. And I say little or no severance because I want to make clear that there is a difference between what amounts to cause for the purposes of the Employment Standards Act and what amounts to cause for the purposes of the common law or judge-made law. So under the Employment Standards Act, there's actually a higher threshold to meet if an employer is going to let go someone for cause. And that essentially means that the employee needs to engage in what's known as willful misconduct, disobedience, or willful neglect of duty that is not trivial. So something that's not insignificant. And that if the employer cannot make out this high of a threshold, they would still be required to pay that employee the minimum requirements under the legislation. Which isn't to say that they would have to pay them anything more if the cause in that case amounted to something that was recognized by common law, but they would still have to pay the minimum amounts under the legislation. So because of the impact this has on an employee, the threshold to meet cause from an employer's perspective is very high. The onus is on the employer to prove cause. And the employer essentially must prove that by virtue of the employee's misconduct or actions, that they signaled an intention to no longer be bound by the terms of their employment. That basically the contract could not be continued, that some form of irreparable harm had been done, and that nothing more could be done other than to summarily dismiss that employee for cause. So typically when we're talking about cause situations, before a decision like that gets made, an employer should engage in a progressive disciplinary structure. This is most often seen in cases where the allegations relate to performance issues, but that's something that my colleague Mackenzie will discuss in greater detail later on. At the end of the day as well, context is going to be important. So each case depends on its own facts. And just because, for instance, you have a case here where someone's let go for cause on the basis of theft, and then in your case, your employee stole something, does not mean that the cases will be treated similarly. A number of factors need to be taken into account when deciding whether or not cause is made out. And those factors include things like the age of the employee at the time they let go, the position they held, and the type of responsibilities that they had. Of course, the exact conduct or misconduct that's being alleged to have occurred, as well as, I just mentioned, whether there was any progressive disciplinary type structure set up in place before that decision was made. So with that said, I'll now turn the floor to Mackenzie, who will talk to you guys about some consequences that flow from a cause decision.
Right, so it's very important that employers are cognizant of the serious consequences involved with asserting just cause. These consequences are for both the employee and the employer. Now, in terms of the employee, these consequences involve, obviously, they won't be receiving any severance or the same amount of severance pay or no severance pay. This is often relied on pretty heavily in the transition period between finding a new job. In addition to that, they'll be ineligible for employment insurance. And then on top of that, there's also a sort of black mark on their file, which means that they'll likely have a greater difficulty in finding reemployment. And in addition to that, there usually is a lack of a reference letter, so this further complicates finding reemployment. In terms of employer consequences, this, as Chris mentioned, the onus is on to prove the elements of just cause is on the employer. So they have to prove that they had the elements of just cause to terminate this employee. So this is a very high threshold, as Chris mentioned, and there's a lot of factors that the courts will consider when determining this. But if an employer cannot prove just cause, This will open the door to a higher damages award. In particular, this will open the door for moral and punitive damages. So what are moral damages? These are damages that compensate an employee for distress and hurt feelings that are experienced above and beyond that which is normally expected when one gets terminated. So employers will be found liable for moral damages when they act in bad faith in the manner of dismissal. So asserting just cause when the employer does not have grounds for just cause, that's a good way to open up the doors for a large moral damages award. So currently in Canada, the highest award for moral damages is $250,000. And that case was argued by our principal, Natalie MacDonald, in the Gallia and Walmart case. In terms of punitive damages, the purpose of these damages is to punish the defendant and to deter them from committing future breaches of this nature. So punitive damages may be awarded in cases where an employer unjustifiably asserts cause for termination. And in terms of punitive damages, the highest award in Canada, it was also argued by our principal, Natalie MacDonald, and that highest award is $500,000, and that is also in the Gallia and Walmart case. So we've gone through and we've compiled a short list of a non-exhaustive list of some grounds that the courts have recognized that are justifiable for just cause.
Yeah, so with that said, I'll start with the ground that is abuse or violence. This would include, of course, physical abuse or violence, verbal abuse or violence, and this is one of the, I would say, most clear examples of what constitutes just cause. Of course, this is not acceptable in any context, including the employment context. So when it comes to an employer trying to assert cause on this basis, the threshold is likely not going to be certainly as high as some of the other grounds. And there is usually not certainly progressive disciplinary structure that's going to be extensive, that's going to be required to have had taken place before or after the first instance of something like this occurred. The one tip I'll say as well on this front is that employers should, if they can, get witness statements. So whether it's an employee pushing another or yelling profanities at another, just try to consider whether or not anyone else was within earshot or viewed that, because that could also go a long way in helping make out the case. But as I said, violence is not acceptable, and it's certainly one of the clearest examples. Mm-hmm. Another example is workplace relationships. This gets a bit tricky, but it's primarily in the context where there is a power imbalance. Say, for example, a manager has a relationship with someone who directly reports to him or her. It may seem consensual, it may seem completely fine, both parties may agree, but that's not to say that down the road an issue doesn't arise. And then things like, why is the more junior employee in that relationship, things like that need to be considered, whether and to what extent the power imbalance is actually influencing that more junior employee to be in that relationship or continue that relationship. So needless to say, it's something you definitely want to walk on eggshells with and be mindful of, because it can really be a headache and a huge problem for both the employer and the employee alike.
In terms of that, just to add to that, it has to be very clear in your policies that these kinds of relationships are not permitted. Yeah,
no, that's completely right, Mackenzie. And that's a point generally is a lot of these things you should be documenting in your policies so that it's clear going into the employment relationship that certain conduct is or is not acceptable.
Correct. Yeah, employees must be well aware of what's expected of them, and employers need to make that clear in their policies.
Most definitely.
Yeah.
So that brings me to a third ground, which is absenteeism. Now, this could be either an employee who is late to work or who is completely absent. And if we're talking about just one absence or one issue of lateness, that's likely not going to amount to cause. But if it's repeated over a prolonged period of time, or even as short as 3 weeks, if there's already several absences and the employee's been warned or spoken to by the employer and told that it's not acceptable, that could be sufficient to make out a case for cause. It's not something that requires as much a progressive disciplinary structure as, say, an issue relating to that the performance of that employee. But it's nonetheless a ground that employers need to consider. And the one other point I'll make about this is that employers need to consider whether or not an employee's absence is at all related to a protected ground under the human rights legislation. So whether, I don't know if it's a case of that employee being ill or suffering from some mental or physical condition that basically renders them unable to come to work that day. But needless to say, employers should carefully consider these kinds of things. And if they believe that something like that could be at play, then a duty to sort of inquire and potentially accommodate could be triggered. So point being, don't make a decision to terminate someone in haste. And this applies not just with respect to absenteeism, but really generally speaking, because there could be things that you may not have considered that by failing to do so could land you in some hot water. And with that said, I'll turn the floor back over to Mackenzie, who will talk about some further grounds.
Yeah, so another ground that often comes up is performance-related reasons or incompetence. So this category of incompetence, it really encompasses an inability to perform basic work functions as required by the employer. So to justify dismissing an employee with just cause, this level of incompetence, it really must fall below the objective standard of reasonable competence. So a lack of adequate skill by an employee who is doing his or her best does not typically permit dismissal. However, an employer who will likely be justified if after several warnings and attempts about this incompetence, the employee still does not improve. So it's not enough for the employer to simply point out the performance issues. An employer must also put in place an action plan to assist the employee in improving their performance. This action plan will require participation, obviously, by the employee. And it could include things like setting up coaching sessions or pointing the employee to certain documents or manuals that contain information that would assist the employee in improving their performance. Another ground that often comes up is insubordination. So this is a kind of misconduct whereby the employee refuses to recognize and submit to the authority of the employer. This refusal, they may also refuse to comply with the employer's clear instructions, policies, and procedures without any reasonable excuse. So as we were discussing earlier, it's super important that your policies and all of your manuals and procedures are all in line and clear so that the employee understands what's expected of them. You can't really rely on an unclear policy as a ground for insubordination if it's not clear to the employee what's expected of them. So usually the courts will not allow an employer to fire an employee for a single minor incident of insubordination unless it was of some real significance. Another ground that we've heard a lot about is dishonesty or theft. So dishonesty encompasses a misconduct that indicates an employee's disregard for the employer's inherent trust in the employee. So examples could be fraud or theft. In one case, the court held that an employee's act of taking food and wine from the golf course that he managed without paying for it was not serious enough to warrant dismissal without notice. Now, they decided this because the employee's job actually involved sampling food and improving its quality for the golf course. So this did not amount to just cause. Where an employer fails to prove that an employee's that the employee had the intention to steal, the dismissal will not be warranted. The courts usually consider this to be too harsh a response to such misconduct. Where the courts have found just cause, an example of one would be where an employee intentionally covers up for a shortage of the employer's inventory and then encourages the subordinate employees to do the same. So in this case, they were able to prove that there was an intention, and this intention actually reflected onto the employee's subordinate, so it spread. And so in that case, they actually did find just cause for termination. Now, another one is a breach of trust. Breach of trust in the employment context typically occurs where the employee exhibits misconduct that promotes his or her interests over that of the employer. One really big one is harassment. So harassment, the Ontario Human Rights Code protects workers from sexual harassment and harassment in the workplace. An allegation of sexual harassment, if substantiated, can amount to just cause to dismiss an employee. However, it's important to note that the allegation must be substantiated. In order to substantiate an allegation, you must have an investigation. So for serious allegations, including theft, fraud, or sexual assault or sexual harassment, the employee must be given an opportunity to respond to the allegations before any termination is warranted. So that's really important. As an employer, though, you do not have to actually wait for a formal complaint to be made in order to start an investigation. In fact, if you believe there's been an instance of harassment, you must be proactive as the employer. And it's really important to be proactive and instigate this investigation before, if you have any indication that there might be harassment. So that's also very important. Finally, there's like a catch-all, so cumulative events. So sometimes a court will find that each act cited against the employee each individual act does not amount to just cause. However, when taken together, numerous incidents of misconduct can amount to just cause. The courts have found that. So this just goes to show that it's very important that you're documenting all of the instances of misconduct of your employees, so that you have, if this is the case, it's going to be a cumulative just cause assertion. Then you have documented everything along the way.
Yeah, just to that point, I'll just say something somewhat to the flip side, in that if you are an employer and you've warned, say, an employee about being late to work, and you've actually given them a written warning to say that this is not acceptable, and then going forward, they no longer report late to work, but subsequently, let's say they engage in some other form of misconduct,
yeah, exactly.
Whether it's like a performance-related issue or whatnot. The employer cannot necessarily say that, oh, well, we've already given one warning, so this is now going to be a second warning, and then use that to possibly build up that cumulative effect. Like, it may be the case that for lack of a better word, clock resets. So you always have to consider, again, each situation on its own facts. And it's also all the more reason why you should be consulting with lawyers or a lawyer before making any decision like that. Mm-hmm. But with that said, I'll now talk to you guys a little bit about some defenses from the employee perspective in response to an allegation for cause. So I previously discussed the interaction between misconduct and a protected ground under the human rights legislation. So that is certainly one possible defense that can be raised by the employee. An example would be if the employee comes into work impaired, whether it's alcohol, marijuana, what have you, and makes some comment, let's say, that maybe they have a problem and it's spilt over into the workplace. Or again, if there's just any reason to believe that that employee may be possibly suffering from an addiction, notwithstanding the fact that they did come to work impaired, you as the employer, if it's reasonable in the circumstances, may need to inquire further and possibly accommodate that employee rather than letting them go. Because then not only will you be potentially on the hook for wrongful dismissal damages, you could be also hit with several other damages as a result of discrimination for not having considered that employee's addiction, or at least the possibility of one, given the employee's words. Another possible defense is condonation. So essentially, when the company condones a certain form of conduct or misconduct, and then attempts to rely upon that same conduct down the road for purposes of letting that employee go for cause, they could face more of an uphill battle.
Yeah, basically, if you've let them do this in the past and you haven't issued any warnings based on that behavior, that kind of condemnation of the behavior.
Yeah, and it's not just you, it could also be other employees. So maybe you're singling out an employee, or an employee feels singled out in that they feel like they're being punished, but everyone else who's engaging in the exact same behavior isn't. That can also be viewed as a form of condemnation on the employer's part. So you got to be consistent, or at the very least, you can't go back and rely on something that you, in essence, waived before.
Right, exactly.
So those are some defenses. And with that said, I'll also now get into what's called after acquired cause, which is a particular form of cause. And it basically means that, simply because you let someone go without cause and provide them with a severance package, if you subsequently discover knowledge or information relating to that employee concerning actions or misconduct that occurred while they were at the office or while they were employed, it's possible for you as the employer to go back and essentially say to the employee, forget the severance package, forget that we let you go without cause. We've now discovered XYZ, and we're asserting what's known as after acquired cause. And it can, in essence, transform then into a causal termination. One of the key considerations, though, needs to be if again, you're relying on something an employee did while they were there and you only discovered it after you let them go without cause, could you have found out about that before? Should you have, reasonably speaking, known about that? Or was it realistically not something you could have found out about until afterwards? Because if it is something you could have or should have considered, again, much like the condemnation argument, it's going to be difficult for you to rely or assert what's called after acquired cause. And another factor to consider is that the more time that passes after the without cause termination happens, the more suspicious as well the courts are going to treat your now new position that you have after acquired cause. However, if that all said, if you as an employer are able to gather enough evidence and information, this is certainly an avenue that you can take. And there's even been cases where minutes of settlement or release has been signed and terms have been agreed to in terms of a severance package, where subsequent to that, conduct was discovered and the court essentially set aside that release and declared that employee was let go now for after acquired cause. And in fact, that employee, in one particular case, had to pay back some money to the employer. So it's never an open and shut case, but certainly the signing of minutes is just another factor to consider in the success of an after acquired cause type claim.
All right, so we're just going to wrap it up with some tips and take-homes for employers. Number one, do not make this decision in haste. Before asserting just cause for termination, it's very important that you seek legal advice. You should seek legal advice in terminating all employees, but in particular, when you're asserting cause, it's very important that you consult with a lawyer. Tip number two, document everything. So you should be documenting all instances of misconduct, all steps that you've taken for disciplinary measures, and any and all warnings that you've given to the employee, among other things. Number three, do not assume just because you have grounds for cause that you do not owe the employee anything upon termination. As Chris discussed earlier, that may not be the case. Number four, include a policy in your employee handbooks or employment agreement that make sure that you're really outlining the kind of behavior that amounts to just cause and the consequences associated with these behaviors. And finally, make sure that you ensure that your termination provisions are drafted in line with the current legislative and common law status.
I'll just add one other thing. It's not necessarily a tip, but just something for employers to be aware of. I mentioned the Ontario Employment Standards Act as being the legislation that governs provincially regulated companies, but there's also the Canada Labour Code that governs federally regulated companies. And unlike the provincial legislation, the federal legislation actually stipulates that an employer is required to provide written reasons in detail as far as the cause is concerned, if the employee requests it. So that's just one difference between the two pieces of legislation. But of course, I would still recommend that when you are letting someone go for cause, because they're most certainly going to want to know what the reason is, given that they may not get nothing, that you do lay out in writing the reasons for that, so that later on, if you need to rely on something, you have that at hand to use.
All right, well, thank you for joining us today. And if you'd like to suggest a topic for next month's webinar, you can email us at socialmedia@mcdonaldassociates.ca.
Thank you, everyone, and have a great day.
Bye.